Hello and welcome to Business Talk, brought to you by the Sharonville Chamber of Commerce. I'm Britt Scarce with Emory Federal Credit Union. I'm your host, and today here in studio we have Karl Ulrich with Sebaly, Shillito Dyer and Pandy Pridemore from The Human Resource USA, here to talk about severance packages. Karl, Pandy?
Hi, Britt. How are you?
Hi, Britt. Welcome to the show. So when we want someone to, leave our company, we help them along to the door. Is it pretty common to have a severance package to go along with that invitation to the door?
The invitation to the door. I like the way you put that.
He wants to make it sound nice.
He wants to make it sound nice. He wants to make it sound.
Don't go away mad.
Just go away.
But by all means.
Yeah. I would say severance agreements are pretty common and becoming more and more so, but I'd say that not every separation from employment is a situation where you necessarily want to see them. So I guess in situations, for example, where you've got a reduction in force or a business downsizing or some other kind of, business downturn where people are being let go because there's no work or because the business needs require it, severance agreements may be more common. It provides an opportunity, a soft landing for some of the employees who are leaving. In other situations, I suppose, where you have disciplinary layoffs or a termination for performance reasons, it might not be as common.
Are these only for, executive type positions?
No, in fact, I think severance agreements can sometimes be for just about anybody who is being let go in certain circumstances. It doesn't really, I don't think, matter if, certainly you see more often a severance agreement in a higher level executive departure, but again, that's not exclusively the case anymore either.
Okay.
I think it's the sophisticated employee that tends to get the severance agreement. And I know maybe Karl will disagree with me, but we don't see employment contracts. We're still at-will employment offers. And very, very seldom is an at-will employment offer written with a guarantee of a severance agreement, or a golden parachute as they used to call them. And I like the term that Karl used in terms of soft landing, because that's normally what an employer will say to me is, look, I hate to do this. Is there any way we can give him a soft landing? But one of the things that your viewers need to really keep in mind as we're even beginning to talk about severance agreements is that these are legal documents. These are not something you take off the internet. These are not something that you resurrect from some other employee you've had in the past or something that you used even 5 years ago. These are legal documents with legal language and very specific to not only the position the individual had, but the state that they're in as employment. And even goes down as specific, Karl, help me out, but with the age and tenure. So there's very, very specific things that are that make these doable.
Yeah, we should draw a distinction too between a pre-existing severance policy, so something that an employer maintains where there's a guaranteed benefit on the front end of employment, or as Pandy puts it, in an early employment agreement at the beginning of employment, which guarantees some severance payment down the road. That's one thing. Another thing is a severance agreement that's presented upon termination. So you may have somebody you're letting go as part of a RIF, or you may have a termination for some other reason. You hand them a severance agreement at the time of termination, say, in exchange for a release of liability and a waiver of potential claims associated or arising from the termination. You're going to be receiving a benefit, a payment of some kind. And there can be lots of different ways that can be structured. But those are really two different things. And I think what we're talking about mainly today is the sort of the at the back end, the severance agreement or the severance package that's presented to somebody upon a termination.
Right.
Is there usually some sort of an agreement that you won't file some sort of a falsely terminated type suit or an age discrimination suit if someone's are well into their 50s or 60s?
Yeah. Well, I mean, from an employer perspective, in addition to wanting to do the right thing, in many cases you want to give the employee a soft landing. But the legal reason for doing a severance agreement is so that you can receive back, in exchange for the money you're paying somebody as part of severance, you get some legal protections. That release of claims, that waiver of liability that the employee gives the employer is the exchange. That's the quid pro quo, and that's part of the reason you do a severance agreement, particularly in in a layoff or reduction in force scenario.
Do employees ever refuse it so that they keep their ability to file a suit?
Well, that's a very, very interesting point, because the document itself should state, and will state if an attorney is doing it, that they have the right to take it to their own legal representation and have it reviewed. And there's a pocket of time that an employer has to, or is legally supposed to, give the employee to do that. So when I hear that someone's refused it, it's because the employer has put it in front of them and said, "Here, sign this."
Yeah.
Well,
Wait
anyone,
a minute.
exactly.
I don't even know what it says. Can you negotiate them? I mean, say, hey, you know,
You can, and many do attempt to negotiate severance agreements. And you know, to Pandy's point, I think it's important to point out that you know, when you provide a severance agreement to a person who's over 40, for example, you are required by law to allow them 21 days to review the document and 7 days to change their mind once they've signed it. In order for a release of an age discrimination claim to be effective, those requirements have to be built into the severance language. So there's certain specific things that a good severance agreement in certain situations must contain. But Pandy's, I agree with Pandy wholeheartedly. You can't just hand somebody, whether it's a over 40 or under 40 severance agreement, you just can't just hand somebody an agreement and say,
this is
okay,
your agreement, sign it.
You have 10 minutes to sign this. We'll
Yeah.
leave the room or not. You know.
Yeah.
But if you don't sign it in the next 10 minutes, we're going to take it off the table. That's not a good idea.
Or the other language that I've actually witnessed is, well, here's your severance pay, but you got to sign this before you get it, and it's one of these, and that you just...
Without even looking at it?
Well, they'll allow them to look at it, but they're holding the $3,000 or the $2,000 or whatever the severance payment is. They're sitting there with a prepaid check, you know, made check, and expecting to do this with, and then you just can't do that. It's just not right.
Yeah. Interesting. The so the employee does have the option of, you know, being able to back out of it even after they signed it for, what'd you say, 7 days?
Yeah, in situations where somebody who's over 40 is signing off on a release or severance agreement, you have to build into that agreement a 21-day review period, and then once it's signed, they have 7 days to change their minds. And you can build in language that explains how you do that. You know, I've done these for years. I think I've only had one situation over the years that I've been writing severance agreements for my employer clients where anybody's actually revoked their signature, but that's happened. It happened for a variety of complicated reasons in that case. But most of the time, once the agreement's in hand, you know, the clock runs on that 7-day period, and then the agreement becomes final, almost always.
Are there any legal issues if you know, if you're letting, you know, multiple people go, if one person gets a different agreement than this person? I mean,
yeah, I think in a
do they have
RIF,
to be uniform?
Yeah, and I think in a RIF situation, you know, Pandy, you've done these too. I mean, I think in a RIF situation where you have a group layoff, we have a group of people who are being let go. There are certain standards you want to put in place that you know, you want the same standards to apply to everybody. In other words, you don't want to be favoring one person over another, applying different criteria for that person. Or, in fact, you know, in certain cases, you may have to even disclose what those criteria are. As I mentioned, there's this special age discrimination release law that you have to comply with, Older Worker Benefit Protection Act, and that has to include a disclosure of the requirements and criteria for selecting people on the RIF. So there are lots of there are lots of reasons to be consistent in your treatment of people in a group layoff scenario.
I can see them all talking in the parking lot, you know, as they're carrying their box out and, you know, getting in their cars, and how much you get? How much you get?
And you know they do, right?
Yo, yeah.
Absolutely, and quite frankly, any employer, and I've only had a few, who've had to do mass layoffs, and we all remember 2009, 2010, which, well, can't forget soon enough. But when you've got those mass numbers, I always beg a company, even if it's not my client, get another set of eyes, a legal set of eyes, or at least a set of eyes that are compliant to look at who you're laying off and why, and then walk through that separation process with them, so that again, they don't tend to, you know, be targeting, or it can't be said that they were, you know,
Treated
hand-picking.
differently.
Yeah, hand-picking.
Yeah.
You got to be really careful with that kind of stuff, and that's why the document has to be written correctly and explained correctly to the employee. It's not something to fool around with.
Now, these severance packages, are they always, a certain amount of money, like just all in a lump sum, or do they continue to get paid for a certain amount of time? Does it include health insurance coverage for a certain amount of time?
It can include any. It can include
All of
any
the
or all of the above. You can pay severance in the form of a salary continuation for a period of a few weeks or months after termination. You can pay severance in the form of a COBRA premium subsidy. You can pay severance in the form of some combination of the two, or any number of other benefits. Payment can be in a lump sum, or it can be in salary. So there are lots of different ways to structure it, and oftentimes it depends upon cash flow, employer cash flow.
Yeah.
It depends upon longevity. If somebody's been with the company for a long, long time, you may want to put them at the higher end of the severance range, and it may be more beneficial for that individual to be paid out over time. Different tax years, if you pay it all in one lump sum, it would be taxable in 1 year. If you paid a salary continuation over a period of months, it might go into the next tax year. So you split the tax liability up for 2 years, and that may be favorable to the employee. So lots of different ways to deal with it, and of course a lot of other things to think about as well. PTO, vacation pay, all those other things that you might
what happens to all that?
Yeah. So you have to consider about whether there are other benefits too that they're owed as part of the policy that's already been in place, or whether you're going to enhance the severance with something that you might not otherwise pay upon termination, like paid out PTO or vacation.
Can this also include maybe letters of recommendation and that sort of thing?
There's going to be a statement in there about unemployment. I mean, absolutely. The letter obviously would go separate. You wouldn't put that as a part of the document for severance, but no, to Karl's point, absolutely. There's just so many ways of working around it, and there is no magic formula. I had somebody call me here 2 weeks ago and say, hey, what's the formula? If he's been here 5 years, or if he's been here 15 years, there isn't any. I mean, I don't know of any. Do you know of any?
No, I mean, I've often told people that a rule of thumb could be 1 or 2 weeks of severance of compensation for every year or so of service. But again, that's just a benchmark. That's just a starting point. And again, more highly compensated individuals may be at the higher end of the severance. Somebody who's been with the company a little longer, maybe a little at the higher end of the severance range. If somebody's only been with the company for a couple months, probably not.
Well, you see stories of CEOs of large corporations that get $15 million.
Well, I can assure you that is pre-negotiated. That's going back to the golden parachute.
Yes, those are golden parachutes.
And those are usually deals that are negotiated
Yeah.
really at the front end.
That's
Those
exactly
are part
right.
of the recruitment incentives to get executives to come to work for a company. They're going to be given those kinds of incentives at the front end of employment for the most part.
Yeah. One of the things that I think sometimes they forget too is any confidentiality statements that have been signed at the beginning of employment need to be reinforced at that time too. So you don't want to, you really don't want to mess anybody up or get anybody upset about the whole situation. But that is, I have seen that.
Yeah. Well, Karl, Pandy, severance packages, a lot of important legal stuff here that employers definitely need to pay attention to and make sure that they do it right. So great information. You've been watching Business Talk, brought to you by the Sharonville Chamber of Commerce. I'm Britt Scarce with Emory Federal Credit Union. Thanks for watching. We'll see you next time.